Good afternoon. My name is Yari Krivoy. I am the Senior Fellow in International Economic Law and Director of the Investment Treaty Forum here at the British Institute of International Comparative Law. And it's my great pleasure today to open the second day of the 34th ITF Public Conference, State Regulatory Powers and Their Limits. So we're examining state regulatory powers from different angles, from the perspective of states, from the perspective of investors. We're also interested in various issues arising in investor-state arbitration, interesting not only for practitioners, but also for academics, for officials of international organizations and states. Around 120 people registered for this conference, but the advantage of the online format is that people can come and go depending on whether they're interested in a particular panel without actually leaving their office or their home these days. So at any time, yesterday we had around between 40 and 70 people, so probably it will be the same today. And the topics today are very practical. So we'll have two panels today. The first one will be dealing with challenges in investment treaty making, and the second one will deal with force majeure, hardship, and the right to regulate. I would encourage the attendees to use the Q&A box, which you can see in your Zoom application. This is how we collect questions. So if you are interested in asking a question, just type a brief outline of your question. We'll promote you and you will be able to ask your questions using video and audio. So we're trying to make it as real as possible. And in the past, the attendees were not able to see other participants, how many people there are. They were not able to message them. So today we're trying a slightly different format. Now you can see how many people actually signed up and logged in at the moment. So you can message people directly. And I would encourage also you to join our LinkedIn group, and the link was in the email which you received. So if you want to get in touch with other people, if you want to follow other events and developments related to the Investment Treaty Forum, please do join this group. Apologies for my unstable internet connection today, so you will see probably me less today than yesterday. If you are on the panel, please mute yourself and share your video. I can see that everyone has already done that. This panel, which we're starting now, should be of particular interest for states. And I looked at the list of participants, and we can see that a number of people from governments joined, including from Canada, Czech Republic, Ecuador, the European Commission, Germany, Mexico, Oman, Singapore, Spain. Several people from the UK government, as well as from the Court of Justice of the European Union. So although we cannot match the range of states attracted by organizations such as OECD or UNCTAD, but still I think it's a good sign that states are interested, and hopefully they will find this a panel of use for them when they deal with their investment treaty drafting. And today we have a very excellent person to moderate our debate, our presentations, Diane Rosert from the United Nations Commission on Trade and Development. She is based in Geneva and serves as economic advisor, economic affairs officer at the UNCTAD section on international investment agreements. She has many years of experience working on international investment treaties and investor-state arbitration. We all know the excellent tool, the excellent UNCTAD tool, which allows us to research investor-state disputes, research treaties, and having participated in a number of UNCTAD meetings myself, I know about the excellent quality of work they're doing to help governments reform their treaties, to train governments. So the panel is in very capable hands. Diane, over to you.
Thank you very much, Jarek. Welcome to this ITF panel on new trends in bilateral and multilateral investment agreements. I'm Diana Rosert. I've been already introduced thanks to Jarek. This panel will focus on approaches taken by different actors in recent investment treaties. At UNCTAD, we have been tracking the reform of investment treaties since many years, and we can see a clear trend towards rebalancing in investment treaties. How does this change the investor-state relationship? Each speaker will make an initial statement of about 10 minutes. We will then try to leave enough time for an interactive discussion, so please post your questions in the Q&A box. Let me quickly introduce the speakers. David Gokrocha is Senior Legal Advisor at the OECD, and perhaps he is best known for his work on shareholder claims under investment treaties, and more recently for his research on investor responsibilities. Robert Hunter is Senior Counsel at Osborne Clarke with many years of experience in international commercial arbitration and international investment arbitration. My apologies. I think I had lost the connection. I'm back now. Let me continue.
As long as it wasn't because you were about to mention my name, that's all.
I was about to say, Professor Janssen Kalamata is surely no stranger to you, as he was the director of the ITF before taking on the position as research associate professor at the National University of Singapore. It's quite unfortunate when the moderator actually disappears. So we will first start with David. David will set the scene for this discussion, followed by Robert and Janssen. I hope this speaking order is fine with you. David, reformed approaches have been taken in virtually all new treaties. For example, investment agreements signed by the EU, the CPTPP agreement signed by Brazil and India, as well as the USMCA. What considerations play a role on the government side when negotiating investment treaties these days? How did the USMCA actually come about? You probably have some research insights on this. David, you have the floor.
Great, thank you very much, and good morning, afternoon, and evening to everyone. UNCTAD and Diana in particular have done great work in their papers on summarizing overall trends. As she indicated, I'll focus on an important recent treaty, the USMCA. The USMCA process saw senior government officials and ministers criticizing investment treaty protection on policy grounds. Most of the criticism is not new, but expression of it by the US and Canadian governments is new. It's interesting to look at the criticism and see whether and how treaty negotiators sought to address it as part of a balance of interests. Let's look first at some criticism from the US, and in particular from the top trade official in the US, USTR Robert Lighthizer. The first area relates to inward investment and sovereignty. Ambassador Lighthizer criticizes both preferential treatment for treaty-covered investors and reduced US power to regulate inward investment. Here's what he said in Congress. I quote, "Number one, on the US side, there are questions of sovereignty. Why should a foreign national be able to come in and not only have the rights of Americans in the American court system, but have more rights than Americans have in the American court system? A US person goes into a court system, goes through the system, and they're stuck with what they get. A foreign national can do that, and then at the end of the day say, I want 3 guys in London to say we're going to overrule the entire US system." So on the inward bound, it strikes me as a question of sovereignty, end of quote. A second related US concern is the dissuasive impact of ISDS on regulation. Ambassador Lighthizer refers to valuable proposed US regulation that was dissuaded by fears of ISDS claims. He said, "We've had situations where real regulation, which should be in place, which is bipartisan, in everybody's interest, has not been put in place because of fears of ISDS." He does not identify the specific regulations that were obstructed, but the dissuasive effect of ISDS on the US, a powerful government successful in ISDS, is noteworthy. A third criticism focuses on government-supplied investment protection as a subsidy and an undesirable market distortion. Lighthizer advocates for a return to market conditions. And I quote, "It's a situation where somebody says, I want to move a plant from Texas and I want to put it in Mexico. And when I go down there, I don't want to take the political risk that AMLO is going to win in Mexico and change my bargain. So I want the US government essentially to buy political risk insurance for me." Our view tends to be that if you want to move a plant from the United States to Mexico, and the economics suggest that, then you should go with the economics. But if you're going there because we are underwriting the investment, we are putting our finger on the scale, we're encouraging to move your plant down there, that's not the job, in my opinion at least, of the United States government, end quote. So he's arguing for a return to the market and an end to the government subsidy. And he criticizes business lobby groups for advocating generally for market solutions, but then lobbying for a government subsidy to protect their foreign investments. He notes that everyone would like to have their investments insured, but that's not how the market works. Ambassador Lighthizer is a former partner at Skadden. He was previously Deputy USTR in the Reagan administration and Vice Chair of OPIC, a US agency which insured foreign investment. So he has considerable public and private sector experience and knowledge. There are, of course, other issues in the discussion, but that is some of the flavor from the US government. Canada said less publicly about its goals on investment. But the prepared remarks by then Foreign Minister Chrystia Freeland, following agreement to the treaty in principle, illustrate some similar concerns to those of the US. Here's what she said. ISDS has cost Canadian taxpayers more than $300 million in penalties and legal fees. ISDS elevates the rights of corporations over those of sovereign governments. In removing it, we have strengthened our government's right to regulate in the public interest to protect public health and the environment, for example. So we see shared views about the undesirable impact of ISDS on the right to regulate, concerns over special rights for covered investors, greater emphasis on the budget impact in Canada, perhaps reflecting Canadian experience with ISDS. Let's look at the treaty. Does the criticism play out, and if so, how? The substantive standards are similar to TPP or CPTPP with a few changes. The ISDS procedures are generally similar as well. In contrast, there are major changes to the scope of ISDS and the conditions to access it. First, most obviously, ISDS under the treaty is eliminated for Canada. SSDS, or state-to-state dispute settlement, applies to all claims involving Canada on either side. Second, the scope of ISDS is narrowed between the US and Mexico, and some interesting conditions apply. There are two regimes, a general regime and a special regime. For the general regime applicable to most claims, ISDS is refocused on issues of discrimination and expropriation. Absolute standards are generally excluded. FET claims and indirect expropriation claims, the most used bases for ISDS claims and awards, are excluded. Domestic exhaustion requirements apply, increasing the role of the domestic courts and the possibilities of resolution before ISDS. In SSDS, claimant government interpretations that exceed their domestic law protection standards are unlikely. Governments also control whether damages or other remedies apply in SSDS. It appears that the general regime reflects the government criticism. Constraints on discriminatory regulation provide protection, but are less intrusive on policy space and government budgets than absolute standards. They raise less concern about preferential rights. The subsidy for delocalization is reduced, and while covered investors still benefit from some special protection, they need to price in more political risk. Alongside the general regime, there's also a special regime applicable to the US and Mexico. I'll just make 4 points. First, ISDS in the special regime retains a broad scope, including for absolute standards like FET and indirect expropriation. There are no requirements for recourse to domestic courts. Second, only certain economic sectors have potential access to the regime. There are 5 specified sectors: oil and gas to a certain extent, infrastructure for public use, some others. Third, specific central government consent is required for coverage. A central government contract is required. Without the requisite contract, investment, even in the special sectors, is subject to the general regime, which, as we've seen, protects in particular against discrimination. Where a central government does sign a qualifying contract in a specified sector, the contract has in effect a default ISDS arbitration clause, providing for arbitration under all the applicable treaty standards. So the investor does not have to negotiate for that. The contract requirement may generate interesting opportunities to negotiate, including over dispute settlement. Separate ISDS and contract claims seeking essentially the same damages from governments may be less likely. Fourth, the treaty as a whole terminates automatically in 16 years in the absence of government agreement. There's also express contemplation of government exit from the special regime and even from ISDS more generally. The exit provisions don't include survival clauses. The references to exit may be linked to the interest in returning to the market and to the investor pricing of risk, but also to another point raised by Ambassador Lighthizer, the existence of substitutes for ISDS in the form of, for example, contract-based arbitration or political risk insurance. There was rapid ratification of the treaty in all 3 countries, and broad and bipartisan support for ratification in the US Congress. Ambassador Lighthizer expressly set out to develop a new coalition for trade policy, including support from both business and trade unions. And limiting ISDS was part of that approach. It will be interesting to see how other governments and constituencies react to the government criticism of the impact of investment treaties and to treaty approaches that seek to address the criticism. Thank you.
Thank you very much, David. This gives us a very good picture of government perspectives, particularly in North America. Now we will turn to the investor perspective. Robert, before you share some insights on your investment advisory work, when you think back at a specific event in the past, let's say the 50 years of BITS conference in Germany, after the signature of the new Germany-Pakistan BIT in 2009, has the tide turned since? If you remember the feeling from that conference, I imagine it was some kind of celebration. I hand over to you, Robert.
Thank you very much. Well, it's very nice to know that the conference from 2009 is still in memory, but UNCTAD in particular played a large role, and it as indeed did the OECD. And it was not only on the occasion of the second German-Pakistan BIT, but actually on the day Lisbon came into effect. And my 3 memories of that huge conference was first, that it revealed, to the surprise of many experienced practitioners, and there were very many experienced practitioners there, a tremendous surprise that the most positive investor protection sentiment in the world was in China. not in the US or in Europe. Secondly, it launched onto the stage the new EU or Commission unit for international investment agreements, then under Jean-Francois Brackland, who was personally responsible for including the magic words FDI in the common commercial policy. And he said we should be much more interested, or most interested, in the change that Lisbon would bring by introducing a role for the European Parliament in European investment policy and lawmaking, which indeed was completely correct. And I think that has been borne out to a very, very substantial degree. And the third surprise from that conference was the tremendous need for discussion between the participants. I recall we had over 80 representatives, or representatives of over 80 states at that conference, including virtually every European Union country, including then the UK. And very few of them, in fact, there'd been essentially no discussion about the effect of Lisbon prior to its coming into force without any transition. Most of that initial discussion took place at the conference. So it was an interesting event, and in retrospect, we probably underestimated the impact even of those big surprises from that conference. And I don't think anyone thought at that point that we'd be where we are today, in particular in relation to the tremendous pressure that ISDS has been put under today. So, I might mention that conference a little bit more later in this short presentation. I feel a bit of an interloper here. Eric said at the beginning that it would be a good idea to give more voice to states. And here I am probably being essentially a representative of industry, although to be fair, I have done World Bank work and I have negotiated treaties as well. So I guess my role is to present a view of industry, but it's not a kind of dyed-in-the-wool 1950s or 60s view of industry. I hope it's quite nuanced. And I want to make 2 points and raise 2 questions in my 10 minutes. The first point is that we start from a position of convergence if by right to regulate, you look at a narrow definition of the objectives of business and human rights and responsible business conduct. And here I'll pay the first of my 2 compliments of the day to David for his excellent OECD paper on business responsibilities and investment treaties. I agree absolutely, from my experience in particular of advising investors, that there has been convergence on the idea that due diligence by business to assess risks for human rights or for responsible business conduct has a central place in the content of business and investor responsibilities. Indeed, that's nothing new. I took part in negotiations of several IGAs and HGAs for a massive investment about 7 or 8 years ago. And to my surprise then, after we'd spent 10 days negotiating a stabilization agreement, essentially, in the form of an HGA supported by an IGA, there was one clause which took about 30 seconds to agree, which was that the stabilization obligations, indeed the whole treaty, would not apply in relation to a change of law, which is a proportionate measure in relation to environmental protection, public health, safety, social requirements, labor rights, or human rights. It literally was not discussed at all. I shouldn't have been surprised because I think it's obvious that both governments and business today are under huge transparent pressure to comply with those levels of responsibility, and therefore there's a common interest. So having made that point, you then wonder, why is there such a discussion about right to regulate today? Because in a way, everyone accepts that it should be there. And I think the discussion is more about the means to achieve it. One result of the 50 years of BIT conference was that I found myself within a few months later as a fly on the wall, indeed an officially delegated fly on the wall, at a tentative opening discussion for what might become one of the more significant IAAs in the next years. And both parties were in reform mode. They had slightly different objectives, I would say, but one of them was above all concerned about three topics which are still topical today and topical to this conference. One was the need to reserve measures of financial prudence. One was, and the biggest concern, I think, was the lack of predictability in the FET standard. And the third was the messiness of MFN, which they likened to spaghetti. And they came up with the wonderful analogy that BITs are like safety belts in a car. They don't sell the car, and they should be designed scientifically. If they're too tight, they will restrain the driver. And regarding in particular the design of FET, the principal concern, they suggested one of a variety of measures to overcome the concern. One solution would be a tighter definition of the FET standard. One would be binding interpretative statements. One would be a pre-qualification of tribunal members who might decide on the standard. And the fourth would be an appeal mechanism. But my distinct recollection is that they were put forward as alternative solutions, not as a joint cumulative one. And I think the analogy of the seatbelt in the car fits the current discussion about right to regulate extremely well. And here's my second compliment of the day, which is to the works of UNCTAD. I regularly read your issues papers. And in your last one I've seen of July 2020, there's a very useful table, which I think appears for at least a second, if not further time, on reform-oriented provisions in IIA, provisions concluded in 2019. It's a very striking table. It lists 15 IIAs concluded in 2019 and has a matrix with 11 reform-orientated substantive provisions during that period. These range from references to protection of health and safety and so on in the preamble, a refined definition of investment, circumscribed FET, clarification of what does and doesn't constitute indirect expropriation, general exceptions for protection of human, animal or plant life, etc., positive promotion of corporate social responsibility, and limiting access to ISDS. And we've heard from David what's arguably yet another one, which is kind of pre-approval of qualifying investment, a bit like the ASEAN model. What is staggering about that table is that no less than 5 had 10 out of these 11 safety belts. A further 5 had 9 of them, and of the remaining 5, all but 1 had at least 7. But it doesn't stop there, because there's a second table, which is ISDS reform elements in IAAs concluded in 2019 relating to the same 15 IAAs. And here there's a stark choice between no ISDS at all, or if you have ISDS, then 9 possible reform elements relating to the ISDS, which, as you would expect, include replacing the system of ad hoc arbitration with a standing court, requiring investors to pursue local remedies, limiting treaty provisions subject to ISDS, setting a time limit for ISDS, enhancing the role of the state in ISDS, such as through interpretations, enhancing the suitability and impartiality of arbitrators, and limiting the remedial powers of tribunals. And what's very striking, of the 5 IIAs, which had the 10 out of 11 substantive reform elements, 3 had no ISDS at all, and the other 2 had respectively 8 and 9 of the maximum possible reform-oriented procedural measures. So to take my car analogy, at least a fifth of the IAAs had 10 seatbelts, and of those fifth, all of them either, well, 3 of them had no engine at all, and the other 2 had kind of distant or 9 measures of remote speed regulation or automatic stopping. Is that good mechanics? I place that question. I think it's a fair question to ask, and I will let you answer it. So I come then to my 2 questions. The first is, well, sorry, before I come to my 2 questions, I'll say a little anecdote. Looking at these tables reminds me of a scene from Amadeus. Those of you who've seen the film will certainly remember it. It's the kind of crowning moment when Emperor Joseph II remarks to Mozart after the premiere of Die Entführung aus dem Serail that it had too many notes. It was an excellent effort. It was something quite new, but it had too many notes. Mozart wittily, and I think injuredly, replied, "There are just as many notes as are required, Your Majesty, neither more nor less." And the Emperor said, "Well, there are only so many notes an ear can hear in the course of an evening. Just cut a few and it will be perfect." To which Mozart floored him completely by saying, "Which few did you have in mind, Your Majesty?" Well, Mozart's final question, I think, is easier to answer in the case of new generation IIAs than in relation to his opera. I think an investor could certainly say you don't need to take the hammer of 10 reform-oriented substantive provisions and 9 ISDS reform provisions or no ISDS at all to solve any existing concerns with the legacy of Methanex and Saluka. So I can now come to my two questions. The first is, why are there too many notes? And the second is, what effect will they have? Well, as regards the first question, I think Robert Volterra hit this this nail right on the head at the beginning of his session yesterday. He said that the right to regulate simply means state conduct. It covers the whole panoply of what BITs are about. So the truth is, I suggest that the aim of these reforms is actually far more than the right to regulate in the narrow sense that David and his OECD paper were looking at. I.e. business and human rights and responsible business conduct. There's another agenda. And I think the second point, which that conceals, is that the broader agenda actually is diverse between different players. And I think Janssen might be touching on this in his talk. I thought he might be going before me, but I hope he might mention it afterwards. That, for instance, in the case of the EU, and this came out of the conference I was talking about at the beginning, I think what's very significant about the EU, apart from the fact it's not a state, or actually because of the reason it's not a state, is that it has no function in investment promotion, at least to the best of my knowledge. Its interest is much more in FDI as an instrument of trade policy, and I think almost above all, in maintaining its hegemony on the acquis communautaire. That's a very far remove from Germany in the late 1950s, which was simply concerned with the mechanics of promoting foreign investment. I think for other states, it's even more nuanced. Well, actually, it's much more nuanced. The EU is not nuanced at all, I think. Others, I've got time, okay, I'll be really quick then and make one quick comment on the question and put my second question. In terms of other states, I think what we might be seeing is the end of MFN. There's no one size fits all anymore. So states which have both import and export interests will want to enter into differentiating treaties to pursue different agenda. And that, I think, will lead to fragmentation, and I think we might be seeing that already. And my last question is, what effect will this have on investors? It's not capable of precise calculation. No one can say that an investment treaty, let alone an investment treaty with particular provisions, will or will not have a particular effect. But what I can say is that they are taken into account. In the investment I talked about, there was an investment committee to make the final investment decision, had 9 streams of information. One of those streams was stabilization. And in that stabilization were 3 or 4 elements: the domestic law regime, the existence of existing treaties, and the adequacy of the IGA. Those are heavily interrelated. You can't strip them out, but it played a role. And it did play a role in the decision between 3 different types of investment. And these also feed on each other. So standards all refer to each other. But maybe on that last question of possible fragmentation, it's a good time to hand over to Janssen. Thank you very much indeed.
Thank you, Robert. So I very much like the seatbelt example because I think it illustrates quite nicely what is going on. Indeed, the stakes are quite high in investment arbitrations, and there seems to be a feeling among governments and negotiators that one fix isn't enough, and that you need different layers of safeguards basically in these treaties. Now, turning over to Janssen. Could investment facilitation discussions at the WTO be a sort of game changer here with a beneficial outcome for the investor-state relationship? Or are there reasons to be a little bit more skeptical?
Very good questions, Diana. Thank you very much. And thank you to Jarek and to the members of the advisory board. It's great to be back at the ITF after all these years. Robert and David have spoken about investment protection, and I will talk about investment facilitation. The formal titles of the old BITs very frequently were investment protection and promotion agreements. But of course, promotion was kind of the dog that didn't bark in those treaties. There were very few provisions addressing it directly, and rather it was understood or thought that that would be a natural consequence of providing investment protection. Kind of, if you sign it, they will come. It's never been exactly clear that that's the case. And so the development I'm interested in is the work that's been ongoing among states, particularly in the WTO for the past couple of years, to engage in structured discussions on the possibility of a multilateral framework on investment facilitation for sustainable development. And at this point, it's attracted over 100 WTO members into these discussions. And the negotiations are focusing on establishing binding disciplines that would be enforceable through the dispute settlement body of the WTO, whereby states would agree to undertake certain commitments with regard to measures meant to promote investment for sustainable development. And the negotiators, the discussants are absolutely clear, or they have made very clear that they are expressly not talking about investment protection. They're expressly not talking about ISDS. They're not talking about investment liberalization. Rather, to read the documents that have come out of the structured discussion, the goals are to enhance transparency and predictability of investment measures, to improve efficiency and speed of administrative procedures, and to establish national contact points, ombudsperson-like measures, among a number of ideas on the table. And the way it seems to be shaking out is some of the proposals are for obligations of result, and some of them are for obligations of endeavor. So some of the obligations of result, just to quote one of the drafts, each member shall ensure that new measures are plainly written, concise, well organized, and easy to understand. Similarly, obligations of transparency with respect to regulation and legislation, and an obligation to promptly publish such regulations and legislation. Then on the endeavor side, there are commitments to the extent possible to, for example, include explanations of purpose and rationale for new laws when they're published, to provide an opportunity for comments on proposed measures, these kinds of things. So it's a pretty wide-ranging menu of ideas on the table, all designed in principle to facilitate foreign investment, to make the environment for foreign investment easier. And the backdrop to this, though, that's quite interesting, is that investment facilitation really isn't a new thing. It's something that, that states already do, and they implement in their domestic law, and they're doing so in record numbers. One can look at the work of the World Bank or the OECD or UNCTAD, APEC, the G20. There are a lot of international actors also in this space, either providing guidance, providing policy assistance to developing states. So there's a question out there as to whether a multilateral framework from the WTO which is not especially known for its expertise in investment or its competence in that area, whether that adds value to what states are doing in their existing domestic efforts, and what other international organizations are doing as well. And I think that's, in a sense, the burden of proof is on the WTO and on the members there to show that this would add value, and that it would add value to establish these as binding disciplines that could result in state-to-state proceedings before the dispute settlement body of the WTO. The other question, though, and the one that I want to focus on, is the interaction that such a multilateral framework might have with existing IIAs. And here I think the challenge is to ensure that a multilateral framework doesn't inadvertently create new risks of liability for states, especially developing ones. And as Diana has very kindly put in the chat, recently I and George Berman, Manjiao Chi, and Carl Savant published a FDI perspective on this issue. And we addressed several concerns that we see in terms of possible unintended interactions between a multilateral framework and IIAs. So for example, if a multilateral framework is binding, if it's a hard commitment, we have concerns that the failure to carry out obligations under the multilateral framework might end up being used as evidence of a failure to carry out IIA obligations. And of course, some treaties do have particular provisions which address the interaction of a breach of another international agreement and a breach of the IIA. And we suggest actually including something like that in the multilateral framework, something along the lines of what's contained in CPTPP Article 9.3. Quote, a determination that there's been a breach of this framework shall not establish the breach of any rules on investment protection or any investor-state dispute settlement. A second concern is that apart from whether or not a breach of the multilateral framework might serve as evidence for breach of an IIA, there's also concern that it might nevertheless just be used as an interpretive marker by tribunals. So for example, the requirements of FET, or the concept of legitimate expectation, might end up being informed by the promises that states have made in the multilateral framework, particularly with respect to transparency or the way in which administrative proceedings are supposed to go and so forth. And here, our thinking is to include language to the effect that this framework cannot and shall not serve as a means to interpret any rules on investment protection and investor-state dispute settlement. A further concern, and the last one that I'll highlight directly here, is the concern about the possible application of an MFN provision in an IIA to incorporate commitments made in the investment facilitation framework into an IIA. And here what we had in mind is that one might work with the idea of treatment and craft language in the multilateral framework to make clear that, quote, the obligations in this framework shall not constitute treatment under any other treaty. And that's very similar to the approach that the European Union has taken in its recent treaties with respect to MFN, and that's EU-Vietnam Article 2.4 sub 5. Now, all of those provisions would have directly be binding with respect to the parties to a multilateral agreement, to the facilitation agreement. But there would remain the question of what would happen if you had a respondent state, which is party to the multilateral facilitation agreement, but you have an investor from a country that's not a party. There is the possibility that, for example, with regard to an MFN claim, some MFNs carve out obligations created under other international economic agreements. But that's not really a majority view, and it's not really enough, I think, to give states solace. So what we suggest is potentially two other options. One is to include language about the nature of the rights being created under the multilateral framework. And so we propose language that the framework does not create rights for states that are not parties to it, or for investors and investments originating from states or having the nationality of such states. And then as well, just a basic statement about the exclusive jurisdiction of the WTO dispute settlement body to interpret and apply the framework. And this is language actually that the European Union has already proposed in the context of the structured discussions. Quote, the dispute settlement body shall have exclusive jurisdiction to interpret and apply the framework. So that's a bit of a whirlwind, but I do think this is a really very interesting development on a whole bunch of levels, not least of which the institutional one of having the WTO potentially becoming involved in creating international disciplines on investment. It's somewhat similar to, in some respects, to what Brazil has suggested in terms of focusing on measures that seem likely to facilitate investment and create a kind of focus on the partnership rather than on the contentious aspect of a failed relationship. But in other respects, it's entirely different. I mean, it doesn't contain the substantive protections that the Brazil model contains. It's simply focused on investment facilitation commitments. But as I say, it's not clear how those are apt to interact with existing IAA commitments. Thanks very much.